Hi, and welcome. Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo. We hope that you're doing very well today, and welcome to the Estate Planning and Elder Law podcast, where we talk all things estate planning and elder law and anything else that we want to talk about. Well, today is going to fall under the estate planning and elder law arena, at least a little bit. The one thing that we've been getting some questions about on the podcast are in regards to property and how can people own property and how to do deeds and what the deeds mean. You know, people look at deeds all the time and don't understand them. And while this isn't going to be a podcast that gets into the nitty gritty of the deeds, we are going to talk high level about the types of deeds that there are and what words you're going to see maybe on a deed, okay? So specifically, I want to talk about rights of ownership. So there are tenancy by the entireties, which are kind of relegated to married couples. So if a married couple in the state of Pennsylvania takes a deed or takes ownership to a property, and if they were married at the time, it is presumed that they are taking it as tenancy by the entireties. Now, a drafting tip is that, I always tell people when you're drafting, make it as specific as possible, as detailed as possible. You want people later to be able to see it, to know what it means. So it never hurts to put tenancy by the entireties behind the married couple's names, husband and wife, tenancy by the entireties. That way it's very clear to a title searcher who comes around later to know exactly what the intent was. However, though, even if it is silent specifically, as long as they were married at the time that they, received the property, it is deemed to be tenancy by the entireties, meaning if one passes, it automatically transfers to the other spouse. Straightforward, pretty easy. Now, how else could you own a property? Well, let's say you have two individuals who are not married. And if they're not married, now the rules are a little different. So this is where, you have to know whether they're married, not married, whether they're just two individuals. So let's say that I own a property, with my friend Lauren, okay? So we're not married, we're just friends, and we decide to go in together and buy a property, maybe for an investment or whatever. Now we have some choices to make, right? We're not married, so it can be Jeff and Lauren, tenants in common, or Jeff and Lauren with rights of survivorship. Now, here's the significance of that, right? Since we're not married and we're single individuals, the law presumes it's tenants in common. Now, that's a little different assumption than what we made if the couple was married, right? So they're single individuals. So the law presumes it's tenants in common, which means if I die, I can pass my interest to my wife, Whitney. I could pass my interest to my daughter, Deanna. I can pass my interest through estate planning, through my will, to whomever I want, okay? Now, what if it said tenants in common as it relates to Lauren? Again, same thing. Presumed we're not married, tenants in common. That means that each of us can transfer our ownership interest, whether it be through a will, through a trust, or whatever. And we both can do the same thing. So she can also transfer it, to her boyfriend or to her parents or to whomever she wants, right? Now, what if it said rights of survivorship? So that would mean we're not married, we're single individuals that maybe we went in on an investment property together, and it says the two of us with rights of survivorship. If I died, it goes to her. If she dies, it comes to me. Now, that would be in a situation where maybe we did go in on an investment together, and I wouldn't necessarily want, her boyfriend or her family to be in on the investment later, and she wouldn't necessarily want my wife or my daughter. She would want to be able to continue to own it and continue to run the property. So you might do rights of survivorship. But the key here and the trick to remember is that you have to be specific, right? So a lot of times when people come into our office, they just assume that it's rights of survivorship, that it automatically transfers. Or maybe the opposite, right? Maybe they just assume that it's tenants in common, and that each individual can transfer their ownership interest how they see fit. That's not necessarily the case. And as I kind of pointed out so far in this podcast, you need to be really clear about what it is and what the intent is. And you do that very simply. In the very top of the deed, you'll say, Jeffrey Belomo, a married man, and, maybe Lauren, a single individual with rights of survivorship, or tenants in common. That says that each of us can transfer our interest. Remember, if it's silent, it's presumed to be tenants in common. If it says rights of survivorship, then it transfers to the other one. Okay? Now, again, in regards to married couples, if they're married at the time that they take the property, it is presumed that it's tenancy by the entireties. If you take a property before you're married, just some advice, okay? Just some friendly advice from your friendly neighbor, right? Your friendly neighbor and lawyer. Be sure to have the what happens if it doesn't work out conversation. That is always a very awkward conversation. And how you title that one is very important, isn't it? Because if I, was not married and I was dating someone and we took a property together, planning to get married later, it's not presumed that it's tenancy by the entireties, even if we get married. So if we intended for the property to transfer to the other person, you have to specifically state it with rights of survivorship. So that can be a little tricky. Obviously, the attorneys and the title companies certainly know the rules. The reason that this came up is just we get a lot of questions in our office at Belomo and Associates. We are an estate planning and elder law firm, and people come in all the time with deeds. And so we just thought, you know what, why don't we take a little bit of time on a future podcast to at least address it, at least talk about it. Do I expect that anyone listening to this podcast is ever going to draft a deed? No, I don't. I don't at all. And certainly that is not the intent. It was more just an informational kind of podcast. So take a look at your deeds. All right. Also, a very good point. After you file a deed, you will have been sent the original in the mail. If you're working with a title company or a law firm, it will probably get sent to the law firm or title company, and then they'll forward it on to you. But what happens if, for some reason, there isn't one, okay? If for some reason you can't find it, if for some reason you lose it, that's okay. That's okay, all right? There is really no significance to the original. You can go down to the Recorder of Deeds office, and you can find another one. So I don't want anyone losing sleep over that. We get that call all the time in our office. Oh, no, Jeff, I don't have the original deed. Does that mean I don't own the property? No, and that is unlike the will, right? We've talked on other podcasts about the importance of an original will. And then if you don't have the original will, the law presumes that you destroyed it on purpose and that you didn't want it to take effect unless we could prove exactly what happened to it, which isn't easy. This is different. Deeds are down at the Recorder of Deeds. I assume it used to be years ago you could pay a quarter per page. I don't know what it's up to these days, but you want to have some dollars on you, some quarters on you, maybe a card on you. I'm not even certain how they're charging these days, but that part isn't important. The fact is you can always pull it, and you don't need the original. But it probably did get sent to you. So just take a look at your important paper area, wherever you keep that stuff. It is probably there. And just review it. Take a look at it. Never hurts to take a look to see what it says. Maybe it will prompt a question. You want to take it to the lawyer. You want to take it to the person that you know to make sure that it says what you want it to say, right? Especially if it's just not you and your spouse. If there's maybe a son or daughter involved as well, you'll want to make sure that it says what you want it to say, because they're not married to you. It either has to say tenants in common or it has to say rights of survivorship, and that will determine whether it transfers automatically to that individual. So never hurts to take a look, see what it is. Certainly ask your professional. We hope that you enjoyed this podcast of the Red Wagon and Estate Planning and Elder Law show, where we talked a little bit about ownerships of property. I hope you had a lot of fun. If you would like to be a guest on this podcast, please give us a call, 717-845-5390. We are filling up the 2023 calendar for guests. Looking forward to this year, looking forward to having some different people on, having some fun. So if you need any more information about estate planning and elder law, reach out to us at 717-845-5390 or check us out on the web at www.belomoassociates.com. We offer weekly workshops in York and Lancaster. We have pre-planning workshops, crisis planning workshops, probate administration, trust administration, special needs planning, among others. If you're a professional and you're looking for credits, be sure to check us out because we do have a professional boot camp coming up in April. I believe it's April 11th in Lancaster, and we would love to have you. It's accredited for 6 credits. We've got it accredited for financial professionals such as insurance agents, CPAs, CFPs. On the healthcare side, we've got RNs, certified nurse practitioners, family and marriage counselors, social workers. So if you're a professional listening to this podcast and you'd like some continuing education credit for free, definitely check out our website. Give us a call. We'd love to see you in April, and we also are having one in October, and we may add some others. If you'd like us to do a private event for your organization, call us at 717-845-5390. We hope you enjoyed this episode of the Red Wagon Estate Planning and Elder Law Show. Hi, I'm Jeff Belomo, and I would like to personally invite you to listen to the next podcast of the Red Wagon and Estate Planning and Elder Law Show, where we are going to talk about types of ownership in the state of Pennsylvania. How do you own your properties? If you're married, tenancy by the entireties. If you're not married or you have it with a single individual, maybe it's tenants in common, maybe it's rights of joints with rights of survivorship. It all depends on how you want it. Different reasons for different folks, right? So check us out on the Red Wagon Estate Planning and Elder Law Show, where we're going to talk a little bit about types of property ownership. We look forward to seeing you there. Have a wonderful day.